I hope that you have obtained some useful information in the above sections. And for this session, we will be having the Q&As, and I and my colleagues will take turn to answer the Q&As. Before we start the Q&A session, I have received many questions from practitioners asking me why the rush to introduce all these new initiatives. I must say that the initiatives are actually introduced to fulfill Hong Kong's international obligation as a member jurisdiction of the Financial Action Task Force. And why the rush? Why in March? This is because basically Hong Kong will be subject to the mutual evaluation process by members of the FATF, Financial Action Task Force, this year. And Hong Kong will have to submit a national report by May this year. And the assessors will actually be visiting Hong Kong later this year to assess Hong Kong's performance in anti-money laundering and also combating terrorist financing. And that explains why we have to introduce all the new initiatives in March. To kick off with this section, I'll be answering a few questions, and then my colleagues will be dealing with other questions. The first question which we have received is in relation to the TCSP licensing regime. The first question is, if somebody is an employee of a limited company and he does not provide company secretarial service to the public, but he only acts as company secretary to the company in question, should he be required to apply for a license? In other words, he is an employee of a limited company, and he is the company secretary of the company in question. In this case, he is not required to apply for a license, because under the ordinance, you have to provide the company secretary service as a business. And insofar as you are only an employee in a company, you are not required to apply for a license. The second question is, does legal professional include in-house lawyers? I suppose this question is asking about whether in-house lawyers, if he provides a company's service, does he need to apply for a license? And the answer is similar to the situation of an employee. If you are an in-house lawyer or in-house accountant, you do not need to apply for the TCSP license to provide the company service. But insofar as you are a lawyer by profession, if you fall within the definition of either a lawyer or foreign lawyer under the legal practitioners ordinance, you are exempt from the requirement of the TCSP licensing regime. The third question relates to CPAs. For a CPA who carries on company secretarial services through a company secretarial company, not audit firm, I think the importance is that company is not an audit firm, does he need to apply for the TCSP license? The answer is yes. If the CPA provides the company secretarial service by way of business through a company, and the company is not a corporate practice as defined under the Professional Accountants Ordinance, then the company itself would have to apply for a TCSP license. But if the director in question, for example, if the company has 3 directors, and one of the directors is a certified public accountant, then the director, who is a certified public accountant, does not need to fulfill the fit and proper test. The other 2 directors who are not certified public accountants would be subject to the fit and proper test. Okay? And if I may refer the other questions to Margaret for her to deal with the questions.
Thank you, Mr. Registrar. So I have received a similar questions. That is whether a certified public accountant carrying on a trust or company service business in Hong Kong as a sole proprietor in the context of accounting professionals is required to apply for a TCSP license. And the answer is yes. And whether he or she is exempted from the fit and proper test, and the answer is yes as well. And in the same question sheet, the audience also asks if the company is registered as a TCSP licensee, whether the licensee information will be made available in any public website. And the answer is only the name and the license and the business premises of the TCSP licensees will be uploaded to the website for inspection. Okay. So for the second one, I received quite a number of questions regarding what is meant by carrying on the business by way of business. So, actually, whether a person is carrying on a trust or company service business will depend on the fact and the circumstances of the case. But according to case law, we will have to take into considerations of a few factors, such as whether the person will undertake one or more than one of the trust or company service business, and whether the person will advertise or publicize the business activities or to receive referrals from other companies, and also whether the person aims to make a profit when he carries on the activity, and fourthly, whether there will be a continuity of providing such a service. And for that, I also received questions in relation to that is, if in other situations, if the company only acts as trustee for one or more private trusts for family needs, then whether the person it needs to obtain a TCSP license or not, and in other cases, whether an individual acting as a trustee for a family trust or for a private trust company set up to administer a single family trust only. So in these circumstances, if the person only accepts a one-off appointment by a friend or relative to act as a trustee of a trust in a personal capacity and with no commercial gain, in that situation, then no trust or company service license is required. And I also received a number of questions regarding whether a member of a group of companies providing company services to that group of companies, whether the member is required to obtain a trust or company service license before they can carry on business for the group of companies. And in these circumstances, if it is in respect of the provision of company services by the member to the other members of the group, and if the member does not receive any charges when the member provides such a service, and the member only provides the trust or company service business to that group of members only, in that situations, no TCSP license is required. Okay? So maybe I'll pass to my colleagues to answer some other questions regarding the trust or company service business.
I've received a question asking whether if the person has already registered with the Companies Registries and other websites, I think probably the e-registries, can that automatically allow the person to use our website at www.tcsp.cr.gov.hk? The answer is simply no. You have to go through the registration process through our website, but I can assure you that the registration process is very simple and easy to complete. I received a number of questions regarding the transitional arrangement. They are concerned about if their application cannot be determined before the 28th of June and what will happen. So just rest assured that as specified in the envelope, if we do not determine the outcome of your application after 28th of June, you can still continue to carry on your trust or company service until we decided to grant or not to grant a license. There's also a question regarding the use of Form TCSP3. The question is whether if there's a change in director, I think it's during the transitional period, are the person required to submit a Form TCSP to report the change? No. Form TCSP3 is to be used after you have obtained your license, and if there are any change after, or you propose to appoint new director, new partner, or ultimate owner, you have to apply to the registrar using a Form TCSP3 after you have become a licensee, namely that we have already granted you a license. Maybe I pass on the stage to...
Thank you. Maybe I can supplement a few points. For the TCSP licensing regime, I would advise practitioners to apply for the license early. Don't wait until the 27th or 28th June and rush your applications in. Actually, on the first date of operation, on the 1st of March, we already received 233 applications. And once we receive your application, I repeat, don't worry. Your deemed license will have effect until your application is granted or rejected. So this applies even after the 28th of June. And under the licensing regime, actually we will be keeping a register of all TCSPs who are licensed with us. And the list will be available at the website of the TCSP registry. And the list will be open to public inspection. Incidentally, we have also set up an inspection team in the TCSP registry. Starting from the 19th of March, which is 2 weeks from now, we will be sending inspectors out to visit your business premises to ensure that the requirements of customer due diligence and record keeping are complied with. So, sometime within this week, if you receive the notices of inspection, don't be too surprised. And we will give you notice and tell you what areas, what documents we would like to have a look at. And if we find that, for example, some of the requirements are not complied with, we will try to explain the relevant requirements to you. Thank you. If I may ask Ms. Ellen Chen to deal with the questions on significant controllers register.
Thank you, Ms. Chong. I have received several questions, all related to Section 653C, so I will deal with them all at once in a go. The first question is whether recognized stock market is restricted to Hong Kong stock market. Well, there is a definition in Section 2 of the Companies Ordinance and by the relevant provisions in the Securities and Futures Ordinance. Recognized stock market means the Hong Kong Stock Exchange. Thus, an overseas listed company enjoys the same exemption as in the case of a Hong Kong listed company. I assume the question is whether if a company has an overseas listed company as its member, is it necessary for the Hong Kong company to continue to trace? Section 653C, subsections 2 and 3 clearly refers to a company listed in the Hong Kong Stock Exchange. So if the company has an overseas listed company as its registrable legal entity, the company, the Hong Kong company, has to comply with the requirements and under Division 2A and to carry out steps to identify its significant controllers, including the giving of notices if required. If a listed company, assuming it is a locally listed company and is listed in the Hong Kong Stock Exchange, holds shares in the Hong Kong company, that is the one which is required to keep a significant controllers register, indirectly. So I take it that the listed company is not a member of the Hong Kong company. The question is whether the Hong Kong company that has to keep a significant controllers register being required to trace the registrable persons that is beyond the listed company. The question is yes, because Section 653C, subsections 2 and 3 do not apply. This question is, my company is a Hong Kong private company. Its ultimate holding company is an overseas listed company. And this listed company, the list of major shareholders of this listed company is required to be disclosed publicly on a quarterly basis. I take it has to be disclosed in the place of the relevant jurisdiction. Thus, my companies do need to send a notice to the ultimate holding company to confirm whether there is significant controllers according to their knowledge. I think there are two issues here. The first issue is when you have a registrable legal entity, do you still have to trace a registrable person behind? And unless Section 653C subsections 2 and 3 apply, you have to continue to trace. The second question is whether there is the duty to issue notice under Section 653P. As I have said earlier on in my presentation, if the situation falls within Section 653S, that is, if the company has already been informed of the status of the person, whether as its registrable person or its registrable legal entity, and the particulars have been provided to the company. Other than that, you have to give a notice under Section 653P. I mentioned that the register, the significant controllers register, cannot be empty. This question is, if the company has 10 shareholders, each having 10% shareholdings, how should the record be made in the significant controllers register? I think the company will first of all have to ask itself, even though there are 10 shareholders, each having 10% of the issued shareholdings, it only means that condition A in Part 1 of Schedule 5A is not being met. Section 653E prescribes that a person has significant control over a company if the person meets one or more of the 5 conditions in Part 1 of Schedule 5A. So you need to consider, apart from condition A, other conditions B, C, D, and E. Even if the person is not a shareholder of the company, the person could still have significant influence or control. And if at the end of the day the company is satisfied that there is no significant controller, the company is required to note in its register the matters specified in Schedule 5C. As in this case, if there is no significant controller, assuming that is the case, then Section 2 of Schedule 5C will be relevant. You may like to refer to scenario case 1 in Schedule 5C. And apart from that, of course, you will still have to put in the name and contact details of your designated representative. I will let my colleague Angelina answer some of the practical questions.
I received a few questions about which company will become an applicable company under the Amendment Companies Ordinance. The question is, are the requirements applied to companies limited by guarantee and not having a share capital? I would like to repeat that the new requirement of keeping the significant controllers register under the amendment ordinance are applicable to all local companies in Hong Kong except the listed company. These include company limited by shares, no matter it is a private company or a public company, company limited by guarantee, and unlimited company incorporated under the Companies Ordinance. Also, non-Hong Kong company registered under Part 16 of the Companies Ordinance is not required to maintain a significant controller register. However, for local companies in the registration, dormant, or winding up process, these companies are still required to maintain the significant controllers register. Limited partnership, sole proprietorship, or partnership are not required to maintain the register. There's a few questions asking about the designated representative. Can an individual who is an employee and a named company secretary of a listed company act as the designated representative of all Hong Kong subsidiaries of that listed company? You may remember that there are two groups of persons that can be the company's designated representative. The first, if the person is either a member, director, or employee who is a natural person residing in Hong Kong, that person can be a designated representative. Or if the person does not meet the requirement, if it is a legal profession, accounting profession, or TCSP licensee, that person can also be the designated representative. So for this case, the named company secretary is an employee of the listed company, then the company secretary can act as the designated representative of the listed company. Whether it can act as the designated representative of all the Hong Kong subsidiaries is whether the company's secretary can meet the requirement. If the company secretary is not the employee or a member of the subsidiary, then he may consider whether he is a legal profession or an accounting professional or a TCSP licensee. If the company secretary meet any of these requirements, then he can also be the designated representative of the Hong Kong subsidiaries. Will the particulars of the designated representative be made public? The answer is no. The particulars of the designated representative is only required to be entered into the significant controller register. There's no form reporting the particulars of designated representative to the company's registry. So since the register is only made for inspection by the law enforcement officer, so the particulars of the designated representative will not be made public. Here's a question about the Form NR2. The question is, the significant controller register is kept with the register of members of the company. The register of member is not kept in the register office, and a Form R2 filed under the old Companies Ordinance, Chapter 32, has been submitted to the registry for registration in the year 2011. Does the company need to deliver a fresh Form NR to report the location of SCR? The answer is no. There's the exemption under Section 653M, subsection 5. Although it only mentions Section 628 in that section, actually there's transitional provision available in Section 628. That means all forms filed under Chapter 32 to report to the location of the register of members can also satisfy the requirement for this exemption.
Thank you. If I may supplement on the question of designated representative, because quite surprisingly, we receive a huge number of inquiries relating to the role and the function and the liability of the designated representative. In short, I would say that under the amendment ordinance, the role of the designated representative is purely to provide assistance to the law enforcement officers in relation to the SCR, the Significant Controllers Register. And the basic liability remains with the company because the designated representative is only a representative of the company. There's no provision in the ordinance which expressly says that the representative incurs personal liability. There's no such provision. And I understand that we still have some questions which we are unable to deal with given the time. And we will try to comb through the questions when we go back, and we'll try to supplement or add to our FAQs on the website. All the relevant materials, including guidelines, external circulars, pamphlets, and all the forms, they are available on the website. In addition, for the Significant Controllers Register, we've already uploaded 2 sample forms on the more commonly envisaged scenarios. So you may have a look at all the materials on our website. And with that, I wish you a very enjoyable afternoon, and thank you.